He's right there talking to the black jacket, the jeans.
Okay, are our timers ready? Okay. I'd like to reopen the forum for Judge of the Santa Clara County Superior Court, Office Number 7, with candidates Cynthia Sevely and Stephen Pogue. My name is Jan Pepper, and I am the president of the League of Women Voters of Los Altos Mountain View area. I will be your moderator for this evening's second forum with candidates for Judge of the Superior Court, Office Number 7. The League of Women Voters of Los Altos Mountain View is bringing this forum to you, and our co-sponsors are the League of Women Voters of Palo Alto, the League of Women Voters of Cupertino-Sunnyvale, and the American Association of University Women of Los Altos Mountain View. The League of Women Voters is a nonprofit, nonpartisan organization interested in the informed participation of citizens in government. The League does not support or oppose any political party or candidate running for public office. Information about the League and opportunities to join the League are available in the lobby outside the door. Voter information about the League and candidates' responses to the League of Women Voters questions and campaign literature from the candidates is available in the lobby, and we encourage you to pick up information on your way out. For more information about tonight's candidates and for voter information on all of the races and ballot measures, please check out the League of Women Voters nonpartisan election website, smartvoter.org. This evening's forums are being taped by the Mountain View Public Access Cable, KMVT, for broadcast on Friday at 11 a.m. and Sunday at 2 p.m. Please check the KMVT schedule for additional times. This tape will be made available to other public access channels for public viewing. So this forum will follow the one we just had, with an opening 3-minute statement from each candidate. The speaker order has been chosen by lot, and the timekeeper will signal when 1 minute remains, when 15 seconds remain, and when time is up. And she's sitting right there with her paddles. After the opening statements, we will have the candidates respond to written questions from the audience. Please raise your hand if you have a written question or you need a card to write a question, and our members with the big League of Women Voter buttons will pick those up from you, and our sorters will go through those and hand those to me. Each candidate will have 1 minute to respond to each question, and we will rotate the speaker order, and since we have only 2, that'll be much easier than the last one. And we'll try to answer as many of the written questions as possible within our time frame. At the end of each question period, each candidate will have 1 minute for a closing statement, and throughout the forum, our timekeepers in the front row will signal the time, and when the buzzer goes off, we ask that you please stop with that question so that it's fair. And I'd like to remind the audience that there is no applause until the end of the forum, and to ask everyone to please silence your cell phones. Now for the second of our evening forums, I'd like to introduce the 2 candidates running for Judge of the Superior Court, Office Number 7. They are Cynthia Sevely and Stephen Pogue. Candidate Sevely will start the 3-minute opening statement, followed by candidate Pogue.
Well, thank you very much for coming on a Thursday night. My name is Cynthia Sevely, and let me tell you a little bit about myself. I've been a prosecutor with the Santa Clara County District Attorney's Office for 28 years. I'm a local resident. I went to St. Francis High School, Santa Clara University for my undergraduate degree. Can you hear me all right? I think not. Can you hear me now? And Santa Clara University School of Law. I'm currently on the Law and Motions Unit, and I handle homicide habeases and search and seizure issues. One of my other jobs is I'm the director of our law school and college internship program. So when students are interested in a career in law, I place them in different divisions of the office, give them in-house training, set them up on different tours, and are a mentor to the law students. But I have specialized in child abuse and elder abuse cases. I was given the Victim Advocate Award for the Center for Missing and Exploited Children. I also did child homicide and elder homicides, and I also did sexual assault cases. I've done just about every assignment in our office. Prior to working for the District Attorney's Office, I worked for my father, who was a probate and estate planner, and I did a little bit of family law. I have been the prior supervisor of the misdemeanor team in our office, and that's where all the new attorneys are assigned. And I established what was called the Vehicular Manslaughter Review Team. And that took the place when when vehicular manslaughters came to our office. We established a team to review them because we didn't want to issue cases that weren't going to make it and then have to tell the victim's family that we could no longer prosecute the case. So we wanted to make sure that we had a very, very good case up front. I assigned an attorney up front to the case, and we did victim outreach. I am endorsed by 47 judges, current and retired. That's the most any of the candidates are endorsed by. 12 law enforcement agencies, PORAC, COPE, numerous local officials, and I look forward to your questions tonight. Thank you.
Mr. Pogue?
Thank you. After practicing law for 19 years, I'm now often asked why I've decided to want to become a judge. I want to be a judge because I want to serve the community into which I was born. If I'm given the privilege to do that, I believe that my experience and my integrity, my education and my dedication, my passion and my compassion will enable me to accomplish a lot of good. I've handled matters in the family law, civil, criminal, probate, and juvenile divisions of the Santa Clara County Superior Court, and I've appeared personally in the courts of 23 other California counties, the federal courts, and the California and United States appellate courts. In that time, I have observed more judges and attorneys than I can count. I've seen excellence and mediocrity. I have seen tireless devotion and placeholding. I'm glad to report that the bench in Santa Clara County that we are both looking to join is exemplary. As we experience this adventure known as life, along the way we all encounter what I call crossroads people. A crossroads person may be a special teacher or minister or doctor or friend or relative who's in the right place at the right time at an important point to make a difference in another person's life. By saying the right thing or giving the right help or showing the right way, crossroads people affect us in ways we never forget and can alter our courses forever. Part of what I have most enjoyed and still most enjoy about the practice of law is that it has given me the privilege of being a crossroads person. I get to be there in times of tragedy and triumph, sharing in the victories, maybe helping bring them about, and lending an arm or a shoulder to cry on when life is not so kind. Being at the crossroads carries a lot of responsibility and requires thought and care. A judge is a crossroads person. Judges are called upon daily to make decisions that change the lives of those who come before them. The likelihood is that the people who stand before the court will always remember that moment, that decision, and how it affected their lives. And a judge does that all day and then goes home and starts it all over again tomorrow. It is a great privilege and an awesome responsibility, one which I pledge, if I am given that chance, never to take lightly.
Thank you. We will now start the 1-minute response to questions from the audience with Mr. Pogue, followed by Ms. Sevely for the first question. How do the courts successfully function under possible severe budget cuts?
That is a wonderful question. It remains to be seen, as I have watched the headlines of late, wondering how, if I get to be a judge, am I going to function? I'll be having to maybe make more copies and punch more holes in things. As I was discussing with judges last night, they're just told, do more of the work yourself. You don't have the staff to bring the file, to mark the file, to take care of things. It will increase the workload of the judiciary, and it may very well impact the ability of the people to achieve justice in the courts that they're paying for.
I think we're going to need to maybe look at volunteers. As the director of the law school and college internship program, I receive more applicants for positions than I have spots for. And I have students who want to taste a bit of the law. So we may need to use volunteers to help us. We may also ask attorneys to volunteer. There are some law firms that do volunteer work within the court. They act as judge pro tems. They take on cases pro bono. So we're going to need to reach out to the community to fill in those gaps.
The next question will have candidate Sevely speak first. What do you see as the greatest obstacles to defendants receiving speedy trials and due process and justice?
Well, the greatest obstacle is money, and there's a lot of behind-the-scenes things that happen, so that if you don't speak English, you need an interpreter. So if there's only a limited number of interpreters on staff that day, there's going to be delays. We have a greater need for Spanish and Vietnamese, but there's other dialects that defendants speak, and sometimes we have to go out of county to get those interpreters. Also, research. If something comes up where the court needs to research it, we're going to have to put the case over. Not all the courts have research attorneys attached. The court has to do their own research. Not every judge has a law clerk. Also, with transportation, a lot of times the public defender's clients don't have phones. They have disposable phones. They can't get a hold of their clients. They don't have money for transportation, so it's very hard for them to get to court. So there's all these factors that go in behind the scene that the average person doesn't know about that affects the court system.
Candidate Pogue?
My experience, having done criminal defense, is the main reason for most delays in the criminal system is that the defendants are not any too anxious to get it done any sooner than they really have to. But where the delays are brought about by the system and not by the desire of the accused to postpone the day of reckoning, all the reasons that Ms. Sevely cited are very valid, especially where you have one interpreter who is running back and forth all day between 4 departments, and you got an interpreter? Send me the interpreter. Dibs on the interpreter. That's tough. At other times, it's simply a matter of attorney scheduling. And we may have a trial set, and I can't do it that week. Well, that's not our trial week. But ordinarily, it's simply that people don't want it to move any quicker than they have to.
For the next question, I have Mr. Pogue answer first. Can you please discuss your view on the appropriateness of instructing juries on the right to disregard bad laws and jury nullification?
I think if a jury decides they want to nullify, I don't think that they're going to be bashful about doing so. It's a rare phenomenon. Sometimes it's called for. I don't believe that any judge should ever tell a jury they have the right to disregard the law if they don't agree with it. I don't believe a judge has the right to disregard the law if we don't agree with it. I may be sitting on the bench and there may be a case come up where I completely disagree with the law, but if I'm selected to do that, I won't have been chosen to go up there and make new laws that please me, but to apply the laws that the legislature has passed.
Well, currently the law is that you can't instruct the jury on jury nullification. So if people have a problem with the law, then that is the position of the legislature to change the law. The judge has to follow the law, so he instructs the juries on the elements of the law, and if the jury then needs to decide whether or not the prosecution has sustained their burden beyond a reasonable doubt. So I agree that currently the state of the law is that we cannot instruct the jury to go for jury nullification.
Thank you. Ms. Sevely, you'll go next.
Okay.
What, in your opinion, have been the most egregious miscarriages of justice in our court system, and why do you think so?
Well, an egregious misjustice is when an innocent person is convicted. And as the previous prosecutor stated, we have a conviction integrity unit, which my boss runs. And so when defendants feel that they were convicted unjustly, they can write our office, and we then open up a file and investigate the case. There are very few convictions that do get reversed. There was a series in the Mercury News talking about some tainted trials, and they looked at our county in addition to some other counties. But anybody can ask our office to review a case. It doesn't have to be the defendant. It could be a defense attorney. It could be the mother of a defendant, and we will look into it and see whether or not it needs further review.
Mr. Pogue?
I believe that when an innocent person is wrongfully convicted of a crime, or an innocent party to a civil matter is wrongfully made to pay damages, that is a grievous miscarriage of justice. It's an equal miscarriage of justice for a guilty person to walk away because of a detail that had nothing to do with the circumstances of the crime. It's equally unjust for a person who has been damaged by the act of another to be denied justice because of a detail that had nothing to do with the circumstances that led to the lawsuit. An attorney's place is to be the guardian of those rights and to ensure that the details are watched, but a judge must be ever vigilant to ensure that the overarching mission of the courts and the judicial system is carried out.
Okay, Mr. Pogue, you'll go first this time. Following on the same theme, what was the greatest injustice that you have personally experienced?
Personally, in my practice, I presume, not to myself.
Can answer it. That's just reading the question.
I recall a case where we had absolute proof that a man was a very dangerous child molester, and the court didn't want to listen to it and gave him 50-50 custody of his 3-year-old child, who he later molested. It stuck in my craw for the last 18 years. I think that probably tops it.
Thank you. Ms. Evelyn?
I think it was a homicide case that I handled. I was prosecuting a mother and her boyfriend for the murder of her 3-year-old son. And what I thought was very troubling is that nobody ever contacted me about the son, not even the natural father, in terms of a burial, anything. And I thought, where is justice for this child? I was the only one seeking justice for this child. Nobody came forward. Nobody came to court to watch and to ask. And that just struck me as very odd that a child could die at the hands of 2 people and nobody called about that child.
The justice system is a remarkably expensive process for litigants. Can you suggest ways for opening access to the justice system to all citizens? Ms. Evelyn, if you could go first.
Well, I'm not sure if the question is towards criminal or civil, but on the civil end, we do have judges that are judge pro tems, where people from the community, attorneys, can hear cases and they volunteer their time. It's a little bit harder in criminal to have a non-judge hear a case. It does happen on occasion in some courts, but both parties have to stipulate. And usually the defendants want to have their matter heard by a judge. But we might be able to use volunteers again to assist in the process, maybe more law clerks, more people in the community that can help give more information about the case so we can get the case moving faster through the system.
Mr. Pogue?
The courts have to be accessible to the people, and as an attorney myself, I know that we aren't cheap. Someone once said, talk is cheap unless a lawyer's doing it. All the judges that I know bend over as far as they can to cooperate and help people who are self-represented understand the process and not mess up. There are limits to what a judge can do. The judge can't come down and sit next to you and help you stand up against the lawyer on the other side. But it is a sad fact that a great many people who have occasion to be in court simply can't afford representation. I don't know of an easy answer except perhaps better education.
Okay, the next question, we'll have Mr. Poe go first. Detention facilities are crowded. Can you discuss what role the judiciary can or should play in this issue through penalties or alternate settlements?
The judiciary is very bound within a fairly strict set of rules as to what sentencing there is. The problem has arisen because the people of the state and the legislature have passed more and more laws criminalizing more and more things, but don't want to open up the wallet to build more prisons. You can't say, lock them up, but not put any place to lock them up. We pay our money, we take our choice. We have to decide which one we want. There are alternatives available to judges in certain circumstances, and they are able to look and try to make the punishment fit the crime. I think where people are not dangerous, we need to be a lot more imaginative, but that again would have to come through the lawmakers, not the law interpreters.
As my colleague said, there are certain crimes where there are mandatory sentences, but crimes that can be served at the local level, I think we maybe need to be looking at work furlough. Way back when, maybe in the last 3 or 4 years, we did have work furlough in our county. So when people were convicted of crimes and sentenced to local time, they could still keep their job, but they would go to jail at night. Unfortunately, it was very expensive, and our county doesn't have that program. But other counties have that program. So I think we need to look at how other counties are able to have work furlough, because we want to hold people accountable for their actions, but we also don't want them to lose their job, because that's going to mean that they're going to go on welfare, that they won't be able to pay their child support, or they may become homeless. So at a local level, I think we have more options.
Well, the next question, Ms. Sevely, you'll go first. Can you express an opinion regarding the growing trend toward privatization of prisons and other detention facilities?
I know that in some states there is the privatization of detention facilities. Again, at the local level, going back to the work furlough, that would be a good thing, I think. If maybe the county can't afford that, if we were able to get a private vendor to have that, so again, people could save their jobs. There are some counties that I think use private vendors, such as San Francisco, with their work furlough program. In terms of the state facility, when you talk with the people who work in those facilities, it's their opinion that they're not trained as well as the law enforcement officers that are assigned to those facilities, because you want trained law enforcement officers who know how to deal with crisis manning those facilities so that in case something happens, they know how to handle it.
Mr. Pogue?
I think it all boils down to accountability. There are certain things that can be privatized. We privatize the building of bridges and the building of highways. We privatize hospitals, and we have public hospitals. But you have to have strict accountability when you're putting the life and well-being of somebody you have locked up who doesn't have a choice about it in the hands of a service provider. Whether that service provider is the state or the prison guards union or a private facility, it all has to be about accountability. Whether that is the answer to the budget crisis, it is hard to say. There are a lot of options that have to be looked at, and then that's something that a judge is not going to decide.
Okay. What have been the most critical judicial decisions made recently, and why do you think so? Mr. Pogue, go first.
I was fascinated by the Supreme Court's decision in Heller, which decided that the Second Amendment applied to the states by virtue of the 14th Amendment. And I was fascinated by the case because of the fact that the first 10 amendments are the Bill of Rights. The 14th Amendment was passed right after the Civil War to ensure that the Bill of Rights applied to the states. And here we are, 150 years later, having a case that decides whether one of the first 10 amendments applies to the states under the 14th Amendment of 1865. I thought it was a fascinating study that we're still having that discussion.
I don't know if there's any one particular case. I think some of the cases that deal with search and seizure on what police officers are allowed to do, because the law is constantly evolving, because there's new things out. There's cell phones, there's tracking devices, there's so many things out there, the internet. And so when the law changes, then the police then may have to get search warrants instead of being able to search at the scene. So I think it's important to be abreast of those cases so we can advise law enforcement what they can and can't do and act accordingly.
Okay. What area of the law intrigues you the most and why?
Well, I think criminal law, because that's where I ended up. I did work for my father doing probate and estate planning, and I'm more of a blood and guts type of gal. I started watching Perry Mason as a child, and I remember my father telling me, because he was a JAG, Cindy, they don't stand up in the courtroom and say they did it. But I did an internship at the DA's office, and I thought it was so fascinating that you get to stand up for the victims, you get to promote justice, and they're very interesting cases. So I like the criminal aspect of it.
I'm fascinated by the appellate courts. I love to pick a case apart and figure out what it hinged on and why the justices decided that it hinged on a certain thing. That's where the law develops, is in appellate decisions. You look, and there's sometimes a very large weight on a very small spindle that turns on one point. And I find it fascinating to see the reasoning that goes into the decision of what law applies and why and how it is applied in determining whether the lower courts reach the correct conclusion or not, and how the law evolves as a result of those decisions.
Does the initiative process, for example, 3 strikes, limit the ability of judges and courts to achieve rational justice? Mr. Pogue.
I think that the initiative process has come up with some really great laws and come up with some really stupid laws, a little bit like the legislature. The legislature are people that are sent by the people. The legislature could have as easily passed the three strikes law as to have had it passed by initiative. It apparently was very popular. Is it perfect? No. But the court does have a way, under certain circumstances, that it can look and say, to apply it strictly in this situation would be unjust, and I will have an escape valve. That is a very important thing for a judge to have.
So with respect to the 3-strike law, the judge has the ability to strike the defendant's strikes, and the defense can bring a motion. It's called a Romero motion, and they're brought a lot of times on, actually routinely on 3-strikes cases. So not everybody who is charged under the 3-strike law is sentenced. Also, our office has a review period, a review team, that even though a person may be eligible to be charged as a 3-strikes defendant, not all defendants are charged with those strikes, because our office looks at the defendant's record, the current crime, and the facts of his underlying crime.
Can you please discuss the practice of excluding people of color from juries? For example, leaving juries unrepresentative of the diversity in our community. Do you believe the system monitors this abuse sufficiently?
Well, the way we get our jurors are from a variety of places. We get them from their DMV if they have licenses or if they're registered voters. So a lot of the minority pool are not registered voters and don't have driver's licenses. So when you look at the pool of people that you have, that's your pool, and there may not be a sufficient minorities in there to reflect a pool of people that you can pick from if you have a minority defendant. So I'm not sure how you change that in terms of getting more minority jurors on your panel when the way you get your panel is a bit flawed if you're trying to get everybody.
As I understood the question, it related more to deliberate exclusion of minorities from a jury rather than simply having them underrepresented in the pool from which jurors are drawn. That is strictly prohibited by case law. You can exclude somebody who happens to be a minority for another valid reason, obviously. But under cases, the line of cases we call Wheeler and Batson, you can't simply say, well, I think I won't have any black people on this jury and I'll just exclude them for that reason. Can't do it. And when if it is challenged and brought up the suggestion that that is what has been done, the court has the obligation to inquire and ensure that any exclusion was for a valid reason.
Thank you. So kind of staying on this topic, what is or has been the impact of racism in the criminal justice system? Mr. Pogue?
I think that question would depend a lot on where you are. Probably less of an impact here than you would have had in, say, 1960s Mississippi. Is there still racism? Racism is unfortunately endemic in humanity. We have a tendency to identify with people who seem like us. It's a trait. Have I here seen racism in the courts that resulted in people being mistreated or treated differently? Very little. I have had cases where I've gotten a pretty blonde young lady off with a slap on the wrist where a young Hispanic male would have gotten thrown in jail for a long time. Is that a good thing? No. It happens. We have to guard against it.
I think sometimes there may be a perception of racism when all the facts are not known. When I was the supervisor of the misdemeanor team, I did get a call one time when an attorney said that he wondered why his client was not given the reduction in a theft case, and his client was a minority defendant, and there was a white defendant who got the reduction. Well, when the prosecutor handling the case did not put things on the record, it turned out that his client, the minority defendant's client, had a criminal history, and the attorney was unaware of that, and the Caucasian defendant had no criminal history. So the prosecutor should have said in open court, the reason I'm making this reduction is because the defendant does not have a prior criminal history. So because that information was not out there, somebody in the courtroom observing would think their two defendants were being treated unfairly, when in fact they weren't. So I think you have to explain your reasons on the record.
Okay, could you both expand on your criminal law experience? Ms. Sevely first.
Well, I've been a prosecutor for 28 years. I have tried every possible case. I've handled thousands. I've done child abuse, child molestation, narcotics cases, homicide, sexual assault, elder abuse, financial crimes. I'm currently on the Law and Motions Unit, so I do appellate work. I have done our North County assignment in Palo Alto. When the Sunnyvale Court was in existence, I was there. I've done restitution hearings for victims. I've done motions to clear people's names when they've been victims of identity theft. I think when you've been a prosecutor that long, you've probably done every possible aspect that you can do in the criminal law system.
Mr. Pogue?
She's got me on criminal law, but I have done felony jury trials. I have done felony and misdemeanor court trials. I have defended guilty people who admitted they were guilty and simply didn't want to be punished any more than they had coming. I've defended guilty people who were guilty of something, but they said, well, I don't want to be hung for a sheep if I only stole a lamb. I have defended probably some guilty people who pretended they weren't guilty. What I have never knowingly done is tried to make a person who was guilty, and I knew they were guilty, get off without having, and pretend they were innocent and lie about it. I won't propagate a lie. It doesn't work for me.
As attorneys, you're required to fulfill continuing education requirements. Can you describe some of the continuing education you've taken part in the last few years? Mr. Pogue, you first.
Most of my continuing legal education has been, in the last few years, has been as a teacher at seminars for other attorneys rather than sitting in the audience. I find that I get a lot more out of it when I have had to dig into it and know the answers to questions that I might get asked rather than just sit there and listen to what somebody else has prepared. And it ordinarily takes you 4 or 5 hours of preparation for every hour of time you spend talking about it, even an area you know really well. Last month, I did a seminar on the evolving area of same-sex relationships in family law and how to deal with the samenesses and the differences, and it's really a burgeoning area. And that was fascinating, and I was on the panel that taught about dividing pension plans in those cases.
Well, our office gives in-house trainings every few weeks, so I end up doing more than the minimum required by the state bar. And because I run our internship programs, I put on training for the law clerks, and they're called brown bags. And so I arrange the speakers, and the speakers' talks constitute MCLE, which is training we need for our license. So I get to pick the topics. I also was a supervisor, so I've had case or training on the elimination of bias, sexual harassment, things like that. So I do way more than I'm required. And actually I enjoy it because I learn about a different topic.
We've run through all the questions, so and we've kind of combined those that were kind of duplicative. So I think what we'll do now, we're at the end where we would have our 1-minute closing statements, and since we have a little extra time, I'm going to give you each 2 minutes, if you'd like to take 2 minutes. And since Ms. Sevely started the opening, we'll have Mr. Pogue start with the closing statements.
Thank you. I believe that my experience in a wide-ranging area of everything that comes before the court, my experience in dealing with the day-to-day problems of everyday people, and applying the law practically in the lives of my clients, my experience in the community dealing with every possible culture and background of the wide tapestry of people who make up our county make me a candidate that will be able to serve very well the variety of people who will come before me every day. While many people have said to me during my practice, "Oh, you must have a lot of cases like this. I'm just one more." And I say, no, you're not just one more. You may be my 300th divorce, but this is your only one. And I can never lose sight of that. If I'm sitting on the bench and if I look down, if somebody is just faces and they're line 5 on the 9 o'clock calendar, I'm doing them an injustice. I have to remember that that is the most important thing that is happening in their lives right then, and treat it with the respect and the attention that it deserves, because they have put me in a position to make a decision about their lives and their problems. And if I can't take that seriously, I don't have the right to be there.
When you want to ask about who you should vote for judge, you usually will ask a judge or maybe your fellow attorney or a neighbor, somebody who you know is in the legal system. If you look at my list of endorsements, I'm endorsed by more judges and commissioners than any of the candidates. And these judges and commissioners were prior public defenders, prosecutors, and defense attorneys, and civil attorneys. I have over 100 attorneys endorsing me. Those attorneys, again, are defense attorneys, prosecutors, family law attorneys, and civil attorneys. Because sometimes as a prosecutor, when you're representing or when you're prosecuting a case, you're going to interact with other attorneys on a case. Like if it was a civil case and we're also prosecuting it criminally, you're going to have an interaction with a civil attorney. So I have a lot of people endorsing me. And I can proudly say that I'm probably one of the few prosecutors where defense attorneys have allowed me to speak with their clients. Sometimes they'll say to me, Cindy, I don't think you have a really good case. I want you to talk to my client. And when I've done that, I've ultimately dismissed the case. But many times what they've done is they've had me talk to their client and they weren't even present. They walked away because they said, I trust you and you're going to do the right thing. Now, if you talk to a defense attorney, they're going to tell you, a lot of them would say, I wouldn't do that. But they did that with me because they know I'm a fair and ethical prosecutor. And I look forward to having you visit my website, and I hope you vote for me. Thank you so much.
Okay, could you please join me in thanking the candidates for participating? And I'd like to thank all of you for coming here tonight and taking 2 hours out of your evening to come learn about the judges and the candidates for Superior Court Office Number 7 in order to make an informed decision when you vote. And we'd also like to thank KMVT for taping this forum. And there is literature in the lobby, and if you'd like to talk to the candidates informally, you can meet with them in the lobby as well. Thank you very much.
Thank you.
Thank you. It goes so much quicker when there's only 2 candidates.
Like when you have